Misyar marriage. Is Misyar marriage invalid, forbidden, and impermissible, or is it permissible? First, we must understand that Misyar marriage, as it is commonly practiced nowadays in many Muslim countries, takes several forms. When it first appeared, it was a marriage that fulfilled all the conditions of a valid marriage, except that the woman would forego some of her rights, such as financial support or overnight stays. But now it may be conducted without a guardian. It may also be without witnesses, and it may be done in secret, with many conditions stipulated, such as waiving overnight stays, waiving financial support, or waiving inheritance rights if one of the spouses dies, or other such rulings. God willing, in this video, I will clarify all the forms of Misyar marriage that are practiced today and whether they are permissible or not. The first thing we have is that if this Misyar marriage is conducted without a guardian, then according to the majority of scholars, the Malikis, Shafi'is, and Hanbalis in their schools, as well as what has been reported from Muhammad ibn al-Hasan, this marriage is invalid and not permissible. It is not permissible for a woman to intend to contract the marriage for herself or for someone else, whether she is a virgin or previously married. This is the first opinion. The second opinion is that of Abu Hanifa, Zufar ibn al-Hudhayl, and al-Hasan, and it is the apparent narration among the Hanafis. It is also a narration from Imam Ahmad, may Allah have mercy on him. And this opinion, and Allah knows best, is the correct one, that it is permissible for an adult, sane woman, especially one who has been previously married, to contract her own marriage herself. This is permissible. And of course, I have discussed all of these issues in detail separately, but in this video, I'm trying as much as possible to summarize the scholars' opinions on the matter. The second issue is if the marriage takes place without witnesses or in secret. So if this Misyar marriage is conducted without witnesses, then the marriage is invalid according to the majority of scholars, the Hanafis, Malikis, Shafi'is, and Hanbalis, according to the official position of the school. And all the scholars have said that if a marriage takes place without witnesses, it is invalid, except for a differing opinion among the Malikis. But if there are witnesses, yet it is stipulated that the marriage remains secret and no one knows about it except the witnesses. In other words, they conceal the marriage, bringing together the bride and groom with witnesses, but instructing them not to tell Anyonidos this count as a valid marriage or not. According to the majority of scholars, the marriage is valid as long as it fulfills the conditions, as long as there are two witnesses, that's sufficient. But according to the Malikis, the marriage is invalid and the marriage must not be kept secret. Okay, the third matter, if he marries her on the condition that he does not spend on her, and this happens a lot now. A man marries a woman in a Misyar marriage, but not, I will not spend on you. So you spend on her, on yourself, for example. Is this condition valid or not? So here, if a man marries a woman on the condition that he will not provide for her, or that she will be responsible for her own expenses, the marriage is valid according to the majority of scholars, the Hanafis, Shafi'is, and Hanbalis, but this condition is invalid and he is still obligated to provide for her. In other words, the marriage is valid, but the condition is invalid. As for the Malikis, they said that if we come across this contract before consummation, the contract is invalid. But if consummation has taken place, then the contract is valid, the condition is invalid, and he's obligated to provide for her. So by consensus of the four schools of thought, if consummation has occurred and this condition was stipulated in the contract, then in this case, the marriage is valid and the condition is invalid. But all of this applies if the condition was made during the contract. However, if the condition was made after the contract, while she's still under his protection, that is after he has married her, he says, no, honestly, I can't afford to provide for you and so on. She replies, that's fine, I don't have a problem with that, I can provide for myself. In this case, this condition is accepted by consensus of the scholars as long as she agrees to it. But, and Allah knows best, I believe that if a man marries a woman on the condition that he will not provide for her, and this is due to his poverty, or because he has another wife and children, and it is the second wife who agreed to this arrangement, and he is unable to provide for more than one household, and she and he have agreed that she waives her right to financial support, then in this case, this condition is permissible and can be acted upon. She is not allowed to demand financial support from him after that, even if this condition was stipulated in the marriage contract itself. This is the opinion of Shaykh al-Islam Ibn Taymiyyah, may Allah have mercy on him. Similarly, if the husband becomes unable to provide financially and the wife consents afterwards, then in that case, she no longer has the right to make a claim. Because if it were not for waiving the obligation of financial support, he would not have proceeded with the marriage, meaning nowadays many men say, no, I can't marry you. She says to him, no, that's fine, marry me and waive the financial support. So it is not acceptable after he agrees to this arrangement for her to later demand financial support, because there are many women who are unmarried and there are few men, and some women, praise be to Allah, are wealthy and seek chastity, but can only find a man who is unable to provide for them financially. So in this case, if she initially agrees to this, and if it were not for waiving the financial support, he would not have married her, then in that case, this condition is upheld and he is not required to provide for her financially. However, if he is able to provide for her and there is no valid reason, and he waives the financial support out of stinginess, for example, then the financial support is not waived and he is obligated in this case to provide for her. Exactly. So this distinction is between her marrying him under this condition when he truly cannot provide for her. So in this case, she does not demand financial support from him. All right. The fourth issue is when a condition is placed on the woman that she must provide for him or give him something. That means she is the one who made it a condition that I marry you, but you have to give me, for example, 1,000 every month or give me a sum of money. This is subject to the same previous disagreement among the majority of scholars. The contract is valid, but the condition is invalid. According to the Malikis, if this is discovered before consummation, the contract is annulled. And if it is discovered after consummation, then this condition is not acted upon. And all of this applies if the condition, brothers, is part of the marriage contract itself. But if this happens after marriage, meaning after he marries her, he says to her, I wish you could give me a sum of money every month, and she agrees to this, then there is no problem. Acts of generosity and good character do no harm. For example, if he marries her and she has children, say, he spends on her orphan children or her children from a previous marriage. As long as this was not stipulated in the contract and was agreed upon after the marriage, then it does no harm. All right, the fifth matter is that he stipulates that he will not divide his time equally with her, or that he will only stay with her for a limited number of nights, or that he will visit her during the day but not at night. And this is the case in most Misyar Marigasha marries her, right? For example, I might tell you 1 hour a week and I'll come during the day, not at night. Why? Because his first wife doesn't know about it in the first place. So this also falls under the previous disagreement. According to the majority of jurists, Hanafis, Shafi'is, and Hanbalis, if a man marries a woman on the condition that he will not divide his time between her and his other wives, such as visiting her once a week or once a month, or coming to her during the day but not at night, as is common now, then the condition is invalid, but the marriage itself is valid. And in this case, he is required to treat her equally with his other wives. As for the Malikis, they said that if this condition is discovered before consummation, that is during the contract and before consummation, then the marriage is invalid. But if he has already consummated the marriage, then the marriage proceeds according to the standard rules, and this condition is nullified. And this, brothers, applies if he married her and stipulated this condition during the contract. However, if this condition was made after the contract, while she is already his wife, then there is no harm in this. And this is agreed upon by all four schools of thought. But what I see, and God knows best, is that if a man marries a woman on the condition that he will not divide his time between her and his other wives, as we mentioned, meaning that he visits her on some days but not others, and does not treat her equally in terms of overnight stays, or that he visits her during the day but not at night, as is most often the case nowadays in Misyar marriages, then this situation falls into one of two cases. The first case is that there is no reason for this arrangement, and he simply prefers one woman over the other. Then this is unanimously forbidden. All four schools of thought agree that such a condition is invalid. According to the majority of scholars, the marriage contract itself remains valid because this condition contradicts the essence of the marriage contract and waives an obligatory right. And this, as we said, applies if the condition is made at the time of the contract itself. But if it is made after the contract, then the marriage is valid and she has the right to forego her right to overnight stays with her husband. There is no issue with this. By unanimous agreement of the four schools, if it happens afterwards, meaning, for example, a man is married to two women and one of them says to him, go to the other wife, I don't want you to come to me, or do as you wish, it's up to you, there is no problem with this. The second situation is when there is a particular reason, such as a man marrying a second wife without the knowledge of the first wife, and he is unable to inform her for some reason. And it is the second wife who has waived her right to overnight stays in the marriage contract. Meaning she said to him, fine, I will marry you and you are free to come to me whenever you wish. And they got married. That is, as long as you married me on this basis, I agree you can come to me during the day, at night, one night a week, or one night a month. And if it weren't for this condition, he would not have married her. In that case, this condition is to be upheld, and he is not required to divide his time or spend the night with her. She does not have the right to demand fairness in overnight stays after that, meaning after the marriage, she cannot say, you married me, so I am entitled to a night just like the others, and she cannot go back on this. She must either accept the condition they agreed upon, or she should give up on it and return to him what he gave her. And Imam Ibn Qudama, may Allah have mercy on him, said that Al-Hasan and Atta saw no problem with daytime marriages, meaning that he would visit her during the day but not at night. And our master Al-Hasan al-Basri used to say that he saw no problem if a man married a woman on the condition that she would have certain specified days in the month. Meaning, for example, he would go to her 1 or 2 days each month. And if they agreed on this, then this condition is to be upheld. Now, the sixth matter, which is very important, and I'm often asked about it, is the condition that there be no mutual inheritance between them. Meaning that he marries her on the condition that he will not inherit from her, nor will she inherit from him. For example, someone comes to me and says, I am wealthy, thank God, and I want to marry a woman, but I'm afraid that if I die, she will inherit a lot of money from me. So I want to marry her on the condition that she does not inherit from me, and she agrees I will give her everything she needs, and that's it. Or a woman who is very well off, a billionaire, marries a man and says, no, If I die, he would take, for example, half or a quarter of my inheritance. So that becomes a problem. So I married him on the condition that if I die, he does not inherit from me. And if he dies, I do not inherit from him. Is this condition invalid? This condition is invalid according to the majority of scholars and is not acted upon. If one of them dies, the other inherits from them. The marriage remains valid according to most scholars, except for the Shafis, who believe that the marriage is invalid if this condition is stipulated in the contract. But the correct view is that the marriage is valid and this condition is not acted upon. The condition is invalid. This is, in brief, the ruling on Misyar marriage in all its forms. And of course, I have discussed it in detail in my explanation. In the Encyclopedia of Jurisprudence, according to the 4 schools of thought. But here, I have tried as much as possible to summarize it. And Allah the Exalted knows best.